Welcome to class number 11 of managing the small enterprise, or as I like to call it, from concept to reality. Today is Thursday, February 10th, and there wasn't anything in the news really that I think merits us discussing, unless I'm missing. I mean, there might be war in Ukraine, which I guess is kind of a big deal, but that just goes to show how crazy the world is, where that doesn't even get that many mentions. In any case, we'll start today. The theme is, after we've covered so many different things already, vision, mission, purpose, culture, finance and accounting, marketing, technology, product development, sales, and corporate development on Tuesday. Today, we are going to discuss the law. So we're going to look a little bit at legal. We're going to look at things like non-competition agreements, non-solicitation agreements, the legal warfare that is known as litigation, touch on trademarks, and so on. So who said this? Basically, behind every great fortune, there is a crime. So that's in The Godfather, but it was actually a quote originally attributed to Honoré de Balzac, the French author. You know, it's funny, without admitting any wrongdoing, for purposes of illustration, I remember I saw The Godfather, maybe not for the first time, but again, around the time I started Watch Mojo. And right out of the gates, I was sued by IGN News Corp, alleging it was a frivolous, meritless lawsuit. I prevailed, taking on an actual lawyer, even though I was a layman. I was not a lawyer, because there was no real merits to it. But I remember when I read this, I go, it's true that behind every success story, there is an alleged kind of supposed crime. I'm being accused of one. I have to go prove that I'm not guilty. But I remember this line sticking with me. And then when you study business, and I alluded to the very successful, popular Bronfman family, fair or unfair, it is factually correct that the original legend of entrepreneurship, Sam Bronfman, in the, I guess, 20s or so, he recognized that because of anti-alcohol bootlegging laws in the US, there was an opportunity for him to basically import alcohol from Canada, literally put them on little boats there, and bring them over the river into the US, and he built his empire like that. So, you know, is that a crime or not? I'm not here to insult the Bronfmans at all. You know, they've done wonderful things since, and, you know, obviously known for far more than that. But, you know, when you read history books about businesses that succeed, yeah, there's absolutely always an opportunistic tendency for an enterprising individual to kind of, you know, that theme of it's easier to ask for forgiveness than permission. You know, like if you think of Google's success early on, it was debated, can they host images on Google Images for their commercial benefit and not pay the copyright holders? Is that even legal? And then they went to trial, and it was concluded that they were not infringing on copyright. YouTube's origins, totally accused of piracy. Viacom sued YouTube for $1 billion. Today, YouTube is a bona fide legitimate business. And I could go on and on. Facebook's origins, if anybody saw The Social Network, right? I mean, it's pretty clear the origins of Facebook are beyond murky. The Winklevoss brothers wanted Mark Zuckerberg to build something that went on to become Facebook. And throughout his history, he's done things that have pushed the law. And so I definitely want you never to lie, cheat, or steal, or break the law, because eventually karma does exist. You will get caught. But at the same time, it would be so disingenuous to say that, oh, you know what, like, you don't sometimes have to the envelope and operate in a legal but gray area that others are not willing to do, because without risk, there's no reward. That's the fundamentals of business and life and finance, risk reward. It's always been like that, right? So it's a very, very delicate balancing act and fine line, but ultimately you will oftentimes find yourself in a position where you see something, where you see someone doing something, and you are asked, should I sue this person? And unfortunately, if you are successful, or there's I think a Russian, I don't know if it's a Russian expression that says the tallest grass gets cut first. If you are promising, have potential, I assure you, there are people in a boardroom, in a virtual Zoom hangout, plotting to take you down. I kid you not, it's not being arrogant or cocky to say that. I became an entrepreneur because there's no sense in false modesty now. I see it. I was a bit stupid maybe about it, but when I was young and I would go into an interview, that person's own insecurity was like, what if I hire this person and their ambition and drive laps me? Sure, we'll call you back for a second round. They would shred my resume, right? So you need to understand that to be successful in life, you're not going to necessarily, you will all step on people's shoulders in a positive way, not to bring them down, meaning nobody is a self-made person 100%, but you will always threaten people, sometimes as an individual, as an employee in a company, and sometimes as an entrepreneur. And that is normal. There's nothing you could do about it. Scarcity is a thing. We all have very limited wants. We all have very limited needs, but as human beings that manage greed and envy and all that and gluttony, we sometimes have a lot of wants, and that creates this competitive dynamic that leads to litigation. So when you are caught in this situation, as much as you have to leave the emotions out of it, you could also only find a solution by understanding the emotions that come with it, okay? I've made so many mistakes on this front, and you get the benefit of learning from my mistakes. A few quotes that I love. The wise warrior avoids the battle. I joke, or it's not a joke, I mean, I kind of anecdotally say when it came to copyright, my record was like 300 wins, I like to think 0 losses, and 7 ties, you know, where I sometimes said, I'm not going to pick a fight with UEFA. If UEFA emails us and says, hey, we understand your top 10 premiership goals is not infringing in your backyard, but our sugar daddy Rupert Murdoch and Fox, Sky Sports pay us $1 billion for these rights. So if we have to come and crush you, even if we lose at the merits, if we have to throw every legal warfare at you, we will do it. How do you feel about that? It's okay to walk away and say, yeah, you know what? We don't need to get into a fight. I beat Rupert Murdoch when he, accused me of violating my non-competition. That was survival. This is more greed. I'm going to give in to fear and walk away from that battle. You have to do that sometimes. It's like that saying, sometimes to win the war, you have to lose a battle. Speaking of military analogy, Richard Smedley was a well-quoted, I think, US Army fella, possibly during the Civil War. You'll have to Google him. But he has this great quote that war is a racket. And absolutely war is a racket, right? If you look at, the Iraq War, it was Halliburton, like kind of just printing money. It was like amazing for them. Long story short, litigation is a racket as well. And that does suck, but you do just have to kind of understand that it is part of, it's like what that judge once told me. If you are in this courtroom taking on News Corp, well, it's like basically you're in the major leagues. But ultimately, it's true. Whenever you get into litigation, the lawyers are the only ones who win. I love this quote from The Clash: I fought the law and the law won. Okay, a little bit of a disclaimer. Not a lawyer. Let's just be very clear about that. Ironic as it seems, this is not legal advice. right? Like I'm going to talk about things as a layman, giving my experience. Don't go like in 2 years saying this crazy guy that was in front of me at McGill said something that is law. Okay? But even lawyers make mistakes. A lot of the pain and suffering that I've had in legal circles don't have actually anything to do with, let's say, me making a mistake. It's that the lawyers basically made an error, unfortunately. It's like that great notorious BIG line, I got lawyers watching lawyers so I don't go broke. But lawyers are not the problem. It's very easy to blame lawyers. People are the problem. Lawyers are burnt out, they're overworked, they're managing clients who themselves are kind of managing greed, fear, wrath, envy, and all that. Okay, so the lawyer is a tool. There are some good lawyers, some bad lawyers. Most lawyers will do the right thing and guide their clients to kind of like a fair, reasonable outcome and settlement. Yes, there are bad lawyers and there are bad cops and there are bad cooks and bad firemen and bad teachers, but generally speaking, you are responsible. You know, you are responsible for your thoughts, your words, your deeds. So let's get right down to it. In the context of startups and business and all that, I will just start off by saying that, like, I guess the two main frameworks that basically serve as the pillar of everything else are the USA, which is a unanimous shareholder agreement, and two, the employee stock ownership program, an ESOP. So when I was at my old company, Ask Men, I started there, and on a positive note, there was a USA and there was an ESOP. So that was good in that it was very clear what my rights were. I was given 2% of the business. I did want to negotiate for more, but I was very young, you know, being Tarofi, very like kind of Eastern in mindset. I was kind of just gratitude, and I wasn't going to go negotiate and say, oh, I deserve more. And frankly, it's because some of my new partners, I kind of looked around and said, okay, this guy owns 25%. There's an investor, the investor owns 45%. These two other co-founders own like 10, 12%. And a few other guys that are kind of at my, you know, early stage key employee, but not a founder, that own 2%. So, I mean, that is a little, and I'm being very transparent here. These are questions that you're going to spend hours on. I'm an open book, right? So it is a bit relative, you know, to me. Not knowing all the context, I was like, I should probably have 5 to 10%, but okay, this guy owns 2, this guy owns 2. If I push for 5 to 10, these guys are going to hate me, be putting sticks in my wheels from day one. Naturally, over the course of my 5-year run there, I was generating like 90% of the revenue. To his credit, my boss was like, okay, because of the ownership structure, it doesn't really make sense that everybody gets paid a similar way. Let's make sure Ash gets bonuses and commissions because he's driving so much revenue, right? So there are other ways. Ultimately, your total income is your base pay, a bonus, commission, and possibly capital gains if you're lucky. But most startup employees, their options and their shares tend to be worth 0. That's just the reality, right? So you have to kind of put all that in a cocktail. Now, the problem with that situation was, every few years, my old CEO boss didn't trust his own shadow. He would want to update the USA and the ESOP. So every few years, I would be given the stack of paper saying, we're updating it. There wasn't, well, that's not true. There were some things that were even called draconian by my lawyers when they reviewed it, but it was like, okay, I was like, I own 2%. I don't really have much power. Who cares, you know? But it created a lot of distrust amongst all the partners because it was like, hey, we're working together 3, 4, 5 years. We're like 20. We just got out of school. So 3, 4, 5 years is like an eternity. And so I was like, this is really causing a lot of distrust, a lack of goodwill, it's almost bad faith. And it toxified the relationship. It kind of scarred me. So when I started Watch Mojo, bear in mind, out of the gates, don't have that much money, we get sued. I was the only one funding it. So I was like, hey, you know what? Like, I'm just going to kind of give you a handshake agreement, a verbal, like, this is what you have, this is what you have. What was good about that is as the company kept losing money and I had to just fund it through credit line and mortgages, I didn't need to go to them and say, hey, we got to update this because for whatever reason. It was good, but it was also bad in that I kind of opened myself up to certain people who were involved early on, and I kind of wanted to give them assurances, and that created ambiguity later on. So, not going to take you through the sordid details. I'm just saying there's always, like the same way we talk about technology debt, you know, if you write code and it sucks and it's not well written, 10 years later, you have technology debt. You also have legal debt, meaning if you don't take care of legal matters, it's going to come back. You might save $5, but you'll pay $20 down the road. So we finally did an ESOP and a USA in 2017. The good news, I kept my word to everybody, but when I tried to clean up those people that weren't around, that didn't live up to their end of the bargain, by and large, most people were happy. I went above and beyond, but there are problems that lingered forever. So again, I kind of learned in the grand scheme of things, it is what it is. But if I had to do it again, I would absolutely tell you, don't rush into signing something on day one. But like by day 30, by day 60, by day 100, even by day 300, you should resolve all that. Don't wait for 5 years after the fact, right? One day we may get into it more. Okay, so the point is, these are two key documents that you want to be really thoughtful about. You want to talk to advisors about, you want to talk to fellow entrepreneurs about. But if you go in a business, you do have to get to them rather quickly. Now, once you have, let's say, the foundation out of the way with your partners, you then have to think of what I call the rules of engagement, the non-competition agreements, the non-solicitation clauses, the non-disclosure agreements, the non-circumvention agreements, right? So, I mean, I could do a whole class on a non-competition agreement since I went to court over a non-competition agreement. I still am scarred over that experience. And you know what? Like in March, it's a bailiff. Hey, lots of papers. What's this about? Oh, wait. News Corp, IGN, AskMen, Fox Interactive versus Ashcan and WatchMojo. Wait a minute, this doesn't sound good. It's not. So I was basically being accused of violating a non-competition agreement that basically said the scope was, hey, don't launch an online men's magazine, which is what AskMen was. And I was like, well, wait a minute. WatchMojo is not an online men's magazine. Okay, but let's keep reading. The territory being a web business was global, which is kind of normal. If you sell your convenience store on the corner of Sherbrooke and McTavish, and the person buying it says, don't go across the street setting up a new convenience store, reasonable. But if you want to go to the South Shore and set up a new convenience store, you shouldn't be prevented from doing that because the territory is a bit different if it's an online business versus something like that. And then the term, again, you cannot, in California, non-competition agreements are not even enforceable. And in Quebec, it's a good thing. We're pretty pro-employee. We don't want employers to kind of prevent you from leaving RBC, the bank, and going to TD and saying you can never work. Now, some of you could say, well, wait a minute, I worked at RBC. The next day, I went and got a job at TD. By and large, entry-level, lower-level employees, courts don't care. Employers are not going to, like when I was at RBC, answering phone calls, as good as I may have been and as good as I thought I was, if I would have gone to TD to do customer service, I'm pretty sure RBC would have not come after me. You know what I mean? But if I was a vice president who set up a new crypto trading platform for TD, and I got to know a ton of people who were cutting edge blockchain engineers and had trade secrets about how to generate billions of dollars and manage risk. And I said, hey, TD, it's been a blast. I'm going to go over to CIBC and build them the same thing. I assure you, they would come down with the fury that I would still be feeling to this day, right? So again, context is king. You have to understand, but make sure you understand at startups what you sign if you are joining one. And if you are an employer, be reasonable because the courts will not clarify and fix your non-competition agreement if it's overly expansive. If I tell employees, you cannot do any entertainment content for 5 years anywhere in the world. That is not fair. It is not, the courts are just going to throw it out. But if I say, well, you know what, you can't go work for another company that covers movies and TV shows and does lists for 3 months, and you're not a junior intern, you're a vice president, you're a manager, you're a director. Okay, the courts are going to say, hey, Mr. Employee, your employer had a very limited term, scope, and territory, which is reasonable for the internet. You're probably acting in bad faith, right? So I know way more than I ever really wanted to know about non-competition agreements. It's the kind of thing where oftentimes both employer and employee forget about, but it's certainly the kind of thing you should not overlook and ignore. Cool? Now, non-solicitation clauses boil down to an employee not being able to poach other employees, contact clients, contact certain suppliers. Context is king. Like if I am, again, let's say, what is a good example? Oh, I'll give you a great example. There's a chip supply in the world. So if I am Tesla and I need chips from NVIDIA, and I have this great relationship and I know pricing and I know how to order it, but I now leave Tesla to go work for Rivian, which is backed by Amazon, which is backed by Ford, and I am best buddies with the NVIDIA chip design, chief seller. Well, you know what, fair is fair. And let's say I'm not in California where there are no non-competes. Okay, I understand why Tesla may say, wait a minute, not so fast. This is unfair competition. In fact, this happened. When Uber wanted to get into the self-driving car market, they went out and they poached somebody from Google's Waymo. I mean, I don't know all the companies and names, but it was a huge thing. And because there were billions of dollars at stake, and in the end, Google prevailed. Uber let go of that guy, paid a massive fine, and to this day, it's still cleaning up the mess, right? So that was a non-competition agreement, but it did involve the concept of non-solicitation, which are all kind of married and interrelated. Non-disclosure agreements are kind of like, okay, so it's one thing if, like, let's say you and I want to discuss a partnership and I go, I'm going to tell you certain things that are non-public, and I don't want you to disclose them to third parties unless I authorize you to tell them and there's a valid reason. And you know what? You can only keep this for 2 years. You got to destroy it. I mean, it's a lot of blah, blah. But the thing that's a bit wonky about this and almost useless is you also have to put something in there that says, hey, I'm going to tell you an idea, but you can't then go and commercialize this idea without me. So it's like a non-disclosure agreement. It's like a spoon with a hole in the middle. If you don't cover that hole in the middle and also say, well, you can't then circumvent me and pursue this without me. But be careful what you ask for. Because if it's a MNDA, a mutual non-disclosure agreement, and a mutual non-circumvention agreement, if I tell you about my idea, come back and say, well, we were discussing them, and I also contributed to this idea becoming something more than an idea, and ideas alone are not copyrightable. So I can't go do that without you. Our ideas melded in this new idea. You know what I mean? So sometimes you can over legalize things, but these are all really, really important. So that's why you should be careful what you wish for. Injunctions. Again, this is therapy, another scar of mine that I'm opening up, a wound that I thought was closed. So I was not actually sued by News Corp, those bastards that I love. And I was not sued for, like, in a trial at the merits where we were going to discuss, like, the facts. We were discussing, hey, should we shut down Watch Mojo until the trial? Which is, like, really bastardly, because then I can't introduce new evidence. I have to just debate what is on the face of the record. So it's like David and Goliath. You got to take the tools that are being used against you and kind of turn it around and stab them back. So injunction is basically, could be provisional, which is like, is the matter urgent? Urgent? I have a house. All of a sudden, I see Esso, Imperial Oil, Chevron coming across my house and digging and trying to put in like an oil tank for an eventual oil station, a gas station. I'm like, whoa, whoa, whoa. That's where my little Joey plays in. That's like my just next to my garden. This is an urgent matter. You go to the court and you're like, hey, this could cause me irreparable harm. If toxic gas flows everywhere, irreparable harm, immeasurable. And frankly, the balance of convenience is in my favor. If you don't dig, you're not going to suffer that much harm. You could dig in a week when we go to the courts to debate this. But if you start to pour oil straight into my backyard, well, there go my tomatoes. The balance of inconvenience is more in my favor. I lose more than you do. And is there a likelihood that at the merit I would win? Yes, it's a freaking residential zone. Why are you putting in ESO? I'm simplifying, but you get the idea. So I couldn't go and argue with News Corp and say, hey, I caused them no harm. I'm a little fly. They're a big elephant. That would have been at the merits. I had to literally go through hundreds and hundreds of pages and say, hey, petitioners argue that the defendant may cause them harm. My lady, may cause them harm is not harm. They're fooling the court saying maybe. You're not going to shut me down over a maybe. Petitioners claim that Watch Mojo may one day compete and become a men's online magazine. My lady, we are not today competing with them. Again, you understand, it was an exercise in English. It was debate. I loved it. I wanted to go there and say, these sons of you know what are envious, jealous, miserable, you know what. And I would have loved to say that. And of course, I'm not saying that, but I'm just saying that's what your human nature wants to do. But I had to keep it cool, which I sometimes can't do. But my point was, I also benefited because the first day came out and they kind of messed up. They called provisional interlocutory, interlocutory provisional. The difference is, and that bought me a bit of time, which then I went and I became a Jedi and came back and kind of killed them. But, you know, I was lucky more than anything else. The only difference is in an interlocutory, I think it's not urgent. So it's like one less test. And I feel like when we went to court, they initially called this interlocutory, but included urgent, but they didn't really need to put urgent. But when we went to court, the judge, the verdict, and was like, you don't cause them irreparable harm. The balance of inconvenience is in your favor. So the fact that she said I was right on 2 out of 3 or 4, that's it. If they continue, the judge has decreed, I don't cause them. You understand? It was kind of very technical and boring, but it was an awesome thrill. But yeah, you know, I really don't know. It's like, there's a good saying, I'm happy I went through it once, but I would never go through it again. What happened is I started doing the research myself, and it was like a big mess. If I would have done that, it would have been a lot of things that the judge would have said, like, okay, this is overruled. This doesn't make sense. I called my father-in-law to give him the news. And, you know, I was interviewing very quickly a lot of lawyers. Some people were like, I'm an expert in divorce law. Others were like big law firms who make big mistakes, by the way, and charge you big dollars. But so my God, that itself is a whole hour of therapy. We need to bring out a couch. But what happened was, irony of ironies, my father-in-law was like, oh, you should speak to this lawyer, maître, whatever. And I was like, okay, fine. I was expecting like some family law, you know. And I told him, I said, oh, they're filing a provisional interlocutory. And she was like, you know, the sensei, the master, the ultimate Yoda. And she kind of took me through it, and I was taking notes. And I was like, okay, so I went to see her like Friday evening, and we kind of laughed, and she was like, you know, basically they don't have a case at the merits. This is just a tactic to outspend you. So the only way you'd win is like, oh, because it's in chambers, it's not a courtroom, the judge could just want to see the lawyers. So if you're not there to put a little bit of context that a magazine is not a video, on the face, maybe they'll side with them. So you should be in the room. So maybe since they want to outspend you, you should just represent yourself. And we're like, ha, 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 ha. But I was like, no, maybe I should represent myself. So it was crazy. But Monday morning I showed up like Mr. Bean. And I sort of, she trained me really well. She kind of told me to stay focused. Without her, with a bit more experience, I realized that injunctions are hard to secure. So I don't think necessarily that they would have done it, but I think it would have been a lot more iffy. So she definitely did train me really well. So yes, even if you ever do things yourself, speak to a lawyer. Sometimes it's better to handle things yourself. I've made A lot of the things that I still have to deal with, it's because I got lawyers involved. And then when the lawyers get involved, it drags out. So sometimes it's better to speak to a lawyer and then handle it yourself. Cool. So copyright is obviously an area that I ended up becoming well-versed in because of what WatchMojo went through. And as I said, I mean, I should have shown you a picture of a very young Justin Bieber. You know, the irony, one of the things that personally really hurt me was like, we were working with the labels. They would come to us. Sony wanted to buy us early on and make us their like local news kind of source, covering, doing interviews with artists, and people rolled into town. But eventually, once we finished the interviews and we started doing biographies and profiles and eventually top 10s, we relied on a lot of clips, and they were like, it's fine. It's once YouTube became a very profitable platform that everybody's greed showed up. So they were like, all of a sudden, the marketing people were like, yeah, we're fine with your videos, but the rights department were like, no, you have to pay us. But we're like, no, we're not a radio station. We're not Spotify. We're not playing the full song. If we do top 10 Eminem songs, you'll hear 10 seconds of, you know, Stan, and then we'll go to commentary, and that's fair use. And you guys have more or less confirmed that. But they would never come and say, yes, you're right. It was always very ambiguous. So to summarize it, the fair use in Canada is called fair dealing. There's 4 tests. Think of the acronym PAIN: purpose, amount, impact, nature. It's basically, what is the purpose of our video? If it's commentary, criticism, like news, satire, generally you may be exempt from copyright. That says, hey, if you want to use any portion of any copyrighted material, you got a license. So the second test is the amount. Ironically, if I take 40 seconds of a Beyonce song that's unreleased, I may have destroyed the value of that song because you may not listen to it or buy it. But I could take 3 minutes of a movie and I'm not damaging the movie's value. The impact is the key. It's what is the impact of my use? I could go out there and play a minute of, you know, Seinfeld and say, this is horrible. It's for society. It's not. It's the greatest show ever. But the point is, that's criticism. But if I were to let the genie out and let everybody see, like, take the heart of copyrighted material, and my use supersedes and replaces theirs, then I adversely affected its marketability. My impact would be causing damages. So copyright infringement is like the first exercise to then say, if it was infringing, what are the damages? So in our case, not only rights holders knew that it wasn't infringement, but they were like, well, we can't go to court and say we're damaging them. For one, our marketing departments are begging them for coverage. And 2, there is no damage. It's like people didn't know who Ozzy Osbourne is. These guys are playing like Queen. Queen was a great example. Bohemian Rhapsody was like the most successful classic rock song. We don't want any credit, but even before the movie came out, we put Queen in every list we ever did because they're a great rock band. And so you could argue, well, look, how do you think these younger generations discover when they're on YouTube? It's because people like WatchMojo playing a very small part, 0 credit, and Queen's obviously success with the younger generation. But the labels like what we did. And then finally, the nature, all right? So a movie, a song, its raison d'etre is not to be licensed. Whereas a Getty picture, Getty only exists to be licensed. So if I take a Getty image and I really criticize it and I break it down, okay, maybe it's fair use, but I can't use a Getty image as part of my album cover, which I then sell and say, oh, it's fair use. No, it's not. You should have licensed it. So purpose, amount, impact, and nature is the framework. And ultimately, to summarize, yeah, commentary was protected. As we created a new work, the way we monetized it was not even viewed as being commercial. It wasn't like we were taking top 10 Ozzy Osbourne songs and selling it for $1 to users. We were putting it for free on the internet for people to watch, educate, learn. And if there was an ad before it, the courts had basically said that kind of arm's length commercial activity with a lower C is not commercial with a capitalized C in the context of copyright. So that was kind of a big deal. And I would study a lot. And what a lot of lawyers would tell me is you actually taking the time to research the law. Lawyers are sometimes lazy in that they just kind of look at something very superficially and they're like, oh, it's very complicated. But then I'm like, well, it's not really complicated. And then also when people abuse these copyright tools, then effectively you could even countersue, but that's really expensive and tedious. And so ultimately, a lot of the critics of fair use say, well, fair use is a defense. I'm like, not so fast. In Canada, there was a Supreme Court case that said fair use is actually an extension of user rights. It's like, we're Canadian, we want to comment, we want to criticize, we are allowed to do this. It is not just a defense, it's a fundamental right. You, the claimant, almost have to prove that it was infringement instead of me, the defendant, having to prove it was not infringement. And that's a key thing because it's a lot easier to defend than to prosecute. So earlier I alluded to this. I'm not going to bore you more with the Alexander thing, but the Alexander thing was really, really interesting. Again, the context was I met a local producer. She talked about some of her projects. The thing that was frustrating really was, I was introduced to this person by an advisor. So already my guard was down. And I'm not accusing anybody of wrongdoing, but it was such a good exercise for me because this was ultimately a producer. She and her husband had her company, and I kind of found a bit of a parallel because my wife and I started our company, and I was even considering investing in their company. I was like, hey, this is a way for WatchMojo to get out of the top 10 listicle clip-based format. And, this was my naivete. I was like, oh, we're a couple. It'll be like, I kind of empathize. In hindsight, yeah, I probably did not and should not have ever even considered that. And as I said, I told her about my book. She told me about her kids' programming, yada, yada, yada. She proceeded to produce a show that is in development on Alexander the Great without me. Okay, so a mistake, though, that I did, if we're going to talk about tactics, again, not accusing anybody of wrongdoing, is when I found out she set up this new company at the same time that we were negotiating, it stung. It's like, not because she's a woman, but it's a bit like you as a human, you feel a bit like, was I two times? Like, what the hell? As we're talking about a project, she sets up another company to do this project. So it was a bit emotional. I was like, that feels a bit like, I let my guard down. But I also then, a legal case. This was an instance of me wanting to be a diplomat and a statesman to resolve it and be like, look, not accusing you of any wrongdoing, but this is a project that I wanted to do and I brought it to you. I'd like to be involved. And I was kind of pleading my case to her. And she's a lawyer, so I knew that she had leverage in terms of legal, but I kind of made the mistake, as I alluded to reach out to Ben Silverman, who was working with her, thinking that Ben would care, that Ben would want to be King Solomon and resolve the matters. If we're going to talk tactics, I kind of spoke to a lot of people in the industry, and I'm not going to name these people because, they didn't give me permission to use their comments publicly. But it wasn't like I was crazy, right? These were all people in the industry, and they're like, yeah, you should definitely probably ask for an executive producer credit. Again, not that I'm accusing her of any wrongdoing, but these people, they're also my buddies and friends in the industry, all very senior. So maybe they were kind of telling me what I wanted to hear, but they're also types of people that would tell me if I'm wrong. And if I'm like, Ash, get your head out of your butt, you don't have an argument here. They were like, yeah, obviously this kind of stuff happens a lot. You should probably be attached to the project, get a fee. And I swear to you, I could care less about the money. When you run a business like WatchMojo, a lot of Hollywood is not that interesting because it's actually not that much money. The company that then pays for the project to be produced, they take on the risk, they get all the money. And some of them were like, this may just be PR. It's a waste of time. It happens all the time in Hollywood. So I was kind of torn. And, I would definitely not have reached out, frankly, myself in hindsight. I think doing that kind of made me chase something and someone and gave them maybe too much leverage in that I had to almost convince of somebody to do something that I felt was, setting aside any legal concepts, again, not accusing anybody of wrongdoing. I was like, if I'm in this person's shoes, I would want this to go away. And I would rather have this person who's obviously passionate about the project, but who has a big media company in WatchMojo on my side. And I could throw them a bone just to kind of make this risk go away. And that's also how you guys sometimes have to manage it. You do have to set aside your emotion. You could even say, on the merits, I don't think I did anything wrong. And she repeated time and time again to her lawyers, look, I did nothing wrong, scram. And it's not about that sometimes. It's about just kind of saying, okay, do you want to say without admitting any wrongdoing, I'm willing to compromise? And if you start a company, there's going to be a lot of employees you're going to have to do that with. You may think and feel like you're not wrong. You may think and feel you are right, but you'll have to swallow your pride and mitigate possible risks. And so what I learned was that, hey, when there have been these disputes, demonstrating, if you want to go, and don't forget, I was an expert at copyright infringement, and I knew how hard it is to prove copyright infringement. So I wasn't going to go accuse her publicly of infringing on copyright. And frankly, it's a public figure. Alexander the Great is a historical figure. Now, years ago, there was a case around Robinson Crusoe, which was also a book. It was kind of fictional, and there was a litigation, a very interesting lawsuit. So I could see some parallels. But what I realized, and I'm sharing this more to go, if you want to be tough, sometimes you can't be a statement and you have to be a bit more, tough as nails. I realized that a lot of cases, it wasn't so much proving copyright infringement. That's like the end outcome at the merits you have to prove. But if you want to apply pressure, I learned, yeah, maybe I was being too nice. Maybe I was being too diplomatic. Demonstrating that the person you are saying, hey, is there some wrongdoing in general, not in this case, but in general, if you're like, I'm accusing you of some wrongdoing, you have to just prove that they had access to your books. When I was reading these cases in Hollywood, oftentimes the producer would say, I didn't even know your book existed, buddy, or I didn't even know your idea existed. You're accusing me of taking your idea or your project or your screenplay. You can't prove that I even knew about it. But I was like, it's very clear to me that any sane judge could say in theory, well, Ash told you about the book. He probably gave you the book. Did you read it? Blah, blah, blah. So in hindsight, what I could have done is just send a lawyer's letter if I wanted to pursue that route. But again, remember what smart people have said, avoid litigation, and said, hey, based on these meetings, based on these exchanges, you, Madame Movie Producer, clearly had access to the books. We need for discovery, otherwise we could depose you, and eventually at court, access Michael Hurst's screenplays and development projects, the movie Bibles. Michael Hurst would throw chairs around and be frothing at the mouth to say, who is this Ashkan Carbis-Frushan in Montreal who is seeking my Bible, my show? Gets on the phone, yells at Ben Silverman, then gets on the phone, yells at Karine. All of a sudden, don't you think that these groups would be far more willing to engage with you than me going to them saying, hey, we met. I don't know if there's been wrongdoing or not, but my feelings are hurt, which wasn't exactly what I said. I used both carrots and sticks. I don't want to lie. And I admit there was emotion at play because I was going to invest in this company. I let my guard down, yada, yada. But here's a friendly tip. I used to read Fortune, and there was always this ad for an info, like a conference. And it was like, in life, you don't get what you deserve, you get what you negotiate. So if you really, really want good advice, it's like you can't always be diplomatic. You can't always be nice. Sometimes you have to be an SOB. Sometimes people will call you the B word or the A word. It's okay. Because if you really feel that you were wrong, and I'm not saying I felt I was wrong, but as a lesson amongst many others, I realized I went about this in the wrong way. I was trying to be a diplomatic, being like, hey, I want to be part of this team. I could help. Whereas I could have definitely played it more, but everything happens for a reason. And, you could stick around to the end of the movie to find out what that is. Now, one thing that I want to talk about is the importance of jurisdiction. Okay, using this example without accusing anybody of wrongdoing, what I learned here was, okay, venue and jurisdictions matter. The same way that I said by virtue of being a Canadian company, when people accused us of copyright infringement, I could say, hold on, slow down. We didn't do anything wrong. And there's a Supreme Court case, fair use exists, fair dealing. I knew that the irony, the paradox was that movie producer's company was based in Quebec. Quebec is the civil code where there's an expectation that parties act in good faith. Could I argue in theory that a counterparty acted in bad faith by meeting me, taking a project I shared with them and doing it by themselves? Maybe. I don't know how the courts would think. She disagreed. She was like, we didn't do anything wrong. I had an opinion. Prove there was any wrongdoing. And I said, okay, do I really want to spend my energy filing a lawsuit? The hypocrite who built the business saying copyright infringement does not apply to Watch Mojo is now accusing somebody of infringing around a public figure, you know, you got to be aware. I was like, okay, at the end of the day, it's a pandemic, like live and let live, like take the high road. So I was like, even if you question it, you still have to get to the merits and prove wrongdoing, which is not obvious. But in California, where she's also domiciled and the company she set up, Starlings, was domiciled, there is this concept of implied contract, where if you as a creative meet a producer and you share them a concept, that actually there's been really, really interesting cases. But do I want to go file a lawsuit in California? And more importantly, here, each party pays their own fees. But what if you accuse a party in another jurisdiction like California of wrongdoing? You go, and then Michael Hurst opens up his project, and it's nothing to do with what you kind of discussed, let's say, then you have to pick up the legal fees for the other party, right? So again, you will always have to do all of this arithmetic before you decide to get hot and heavy in a lawsuit or not, because once you initiate this process, it's very long, it's very tedious. Cool? Not too much information? All right, let's move on to trademarks. So trademark, you guys remember this. Trademarks are intended to avoid confusion. So it's kind of weird. Marriott launched a brand called Delta, not to be confused by Delta Airlines. This is a bit confusing, right? Wouldn't you think like Delta Airlines has this hotel? Like I find this confusing, but I guess Marriott disagreed. There was this guy recently who shamelessly cloned Wordle, which the New York Times eventually bought. I don't know if you guys heard this online, but it was kind of like a big kerfuffle online, and it was a bit weird, but anyway, it's an interesting case. So trademarks are all about protecting your reputation, goodwill, and brand. Lil Nas X, he basically launched Satan Nike shoes with the Nike logo, which, does anybody think Nike authorized this? They did not. So the two concerns are consumer confusion and brand reputation. OJ, Hertz, I'm sure they regret that one. So as I've alluded to, again, it's not an emotional matter, but just using my experience with the trademark. So Watch Mojo was a video kind of project out of the Mojo Supreme Incubator. We have a number of brands using Mojo, not just Watch Mojo, Miss Mojo, Mojo Plays. We also have actually Mojo TV. And, you know, we've kind of like been doing this for 10 plus 15 years. It's a house of brands. I've outlined the parallels between other portfolios at Nike, at Time and Viacom. You know, it's kind of like pretty transparent about how it works. And as I alluded to earlier, a couple of years ago, I found out that Ben Sherwood, who, by the way, we'll get to what he's been up to recently, that this fella, former Disney TV chief of news at ABC, is launching a sports tech startup, Mojo. So I'm like, okay, sports tech startup, how bad could it be? But then the article that talks about it, out of the gates, a search on YouTube. I'm like, well, wait a second, a search on YouTube, that's the context that we operate in. We're known, Watch Mojo is basically, that's our stomping grounds. And then he talks about a mobile app, storytelling content, original short form videos, a new brand. And he for sure would talk about lack of awareness. Like I admit that as the guy who built the business around fair use, to go out there and accuse people of copyright infringement, kind of tone deaf. But I'm like, for sure, it's about building a successful new brand. I'm like, how is this a new brand? We've built this brand. We've built this brand exactly where you want to build this brand. So I was kind of like upset. And again, like I broke this down to a couple of trademark lawyers that I know, and I said, am I crazy? They're talking about youth sports. We've been serving the youth market. We cover sports content. You know, we have apps. People, teachers, students, they use us. And our counsel said, yes, they admit that they will be doing youth sports related entertainment content, which is a problem if they continue to do so. And remember, we had registered at the time Watch Mojo. Mojo was something that we were not yet trademarked. We since have, because we're like, we need to figure out exactly with trademarks, you got to define your use really strictly. And we were using Mojo in so many things that we were like, once we're very clear on what Mojo TV is, we'll do it even though it was being used. But nonetheless, John Gruber, one of the foremost experts on all things Apple, just a good reminder, unregistered trademarks are still trademarks. Trademarks rights start and accrue through usage, not through registration. And in fact, this is some other third-party company, there is even a Mojo Sports. So it's interesting that Ben Sherwood and his gang ended up registering this and pursuing this, even though there's a clear conflict with this company. And so, you know, we reached out to them through their counsel and said, look, you guys are about to launch in early February. It's a pandemic. I was like, I don't want to be the crazy guy from Montreal who shows up in LA, files an injunction, which we would probably secure. It's a pandemic. People don't want to be doing this right now. And so they were like, sure, through their counsel, they said, we believe that, our use will be well within the spirit of our discussion. I swallowed my pride. I said, fine, so long as you're not going about there creating confusion. And then ultimately they launched and they posted a bunch of stuff that was clearly a big FU finger to me. And it's fine. In the end, like, it's fine. C'est la vie. But when we pointed things out, they start to take stuff down, which again is kind of maybe not necessarily a sign of wrongdoing, but it's a sign of bad faith. And so I was like, again, being too nice. I hate to have done this. I should have. You're not doing it. You're hiring a lawyer. It's just money. As much as you want to be the classy statesman, they're all going to be hypocrites and they're all going to think you're crazy anyway. We should have just said, hey, here's a simple, short and sweet injunction to put them on the defensive. But by virtue of giving them the benefit of the doubt and saying, hey, look, it looks like you guys are acting in bad faith, the lawyer was like, let me scramble to figure out what happened. And in the end, like Russell Wilson also is an investor there. He's a quarterback for the Seahawks. It was yet another reminder that, oh, wait, now also just to insult to injury, doing lists, which makes no sense for their business model, but as a kind of an FU. And sure, Ted Lasso is a soccer coach, but they're totally now going into entertainment-related programming and coverage, which is what we do, which shows a clear bad faith, but it's fine. Karma exists. What is that karma? So my concern was always, and one reason why WatchMojo's never launched like an academy for young YouTube creators is because I'm afraid it'll draw pedophiles. We're going to be very transparent. I'm like, hey, if we get teenagers to come to learn about how to become YouTubers, what if some sicko says, hey, it's a great canvas for me to go and, kind of get close to kids, right? I've always said that. I said, I don't want that risk. I don't want to manage it. I don't want to wake up one day and find out some guy who's on our team is a sicko. So I kind of said, it's not really worth it. My concern was, well, this is LA, the community that enables and practically promotes the Harvey Weinsteins and the Bill Cosbys of the world. So my concern was, what if they hire these sickos? And then people say, hey, Mojo hired a bunch of pedophiles, for example. That was really one of my bigger concerns, not just consumer confusion. But then I said, look, let's a quasi-hypothetical for you. Let's say Bob is the head of a media company and Mo is promoted throughout Bob's tenure, but Mo turns out to be an alleged sexual assaulter. What responsibility does Bob have? I would feel a bit of a responsibility if somebody was promoted on my team who was a sicko. And then, oh my God, look at this. This gentleman, Michael Korn, allegedly accused of a lot of bad stuff. He was an executive producer at ABC News. And what I realized was basically, coincidence? He was there at the same time that Ben Sherwood was. So again, maybe it's just a coincidence. But what if Ben is the head of a media company, ABC News, and Michael is promoted throughout Ben's tenure, but Michael turns out to be an alleged sexual assaulter? What responsibility does Ben have? So this is Ben Sherwood. This was my concern. I was concerned that, it could happen again at Mojo and Ben goes out and hires a sicko. So Ben today is running this organization involved in youth sports, which is again a magnet for child predators. But now Bob wants to build a brand that prima facie encroaches on my brand that I built, that our team built, and it might create confusion. So this was my concern. I should have done an injunction. There was no doubt about it. And I was like, all these investors that invested in him, whom I know may be upset at me, but the hell with them, because they basically gave me the one finger salute by doing all this in a way. We objected, but due to COVID, we didn't do it. And they basically, their lawyers, after they launched, which is before launch, we would have had all the pressure. They said, look, they're stepping back from what they agreed to do. They've been all over the place, blah, blah, blah. No character, not surprising. So what about Bob or what about Ben? Did Ben himself do anything wrong, or was he just through association with the other guy? Was I crazy? Well, not really. Ex-ABC News boss Ben Sherwood, founder of Mojo, accused of creepy sexually harassing behavior at Disney on network. So when I saw this recently, I was like, mother, you know what? So basically, yeah, ABC News president Kim Godwin has said that she would request an independent investigation into Michael Korn and Ben Sherwood, but basically they're not going to have any more comments. I'm sitting there going, oh my God, oh my God, this was exactly what I didn't want to, oh, did you know the founder at Mojo is a creep? Ash? Wasn't even there. Oh, what? He left? No, Ben Sherwood, that guy. So there is confusion. And again, you guys, I can't believe I'm saying this. You can't be too nice. You can't be too diplomatic. Sometimes you have to be a bit of a tough SOB. And again, Mojo is partnering with Mandalay Sports Media and Randy Chastain. I would love to know what she thinks about Ben's accusations against him. And Russell Wilson, a wholesome character. Am I crazy, or am I just so saying that it just blew your mind is my question, right? So again, it is a bit paranoid and crazy, but when you spend 15 years building a brand, this is what you have to deal with. So odds and ends. One, yes, question. In hindsight, the question was, should I have done an injunction? I hate to admit it. Yes, I should have filed an injunction in December, right before Christmas, right before Hanukkah, right before Kwanzaa, at a point when nobody wanted it. Have a judge just listen and go, yeah, look, if you're going to be in youth, if you're going to be producing sports, if you're going to be on YouTube, prima facie, we're going to grant an injunction so that at the merits, 6 months in a year, that would have frozen them. I could still do it. A judge may say, well, why did you wait? I could say they're still small. We are still trying to resolve it. I could also say, well, there's new information. And turns out is accused of wrongdoing. My reputation. So it's a great question. You should come on the road with me, because at the same time, you can't sit on your rights, but I technically have 3 years. The statute of limitations or prescription in our jurisdiction, you have 3 years. But if you're going to claim something is urgent, then you better not wait 30 years. But don't forget, when we looked at injunctions, provisional injunction requires urgency, interlocutory does not. But yes, I think in hindsight, we should have had that on the record, because then pointing to Ben Sherwood again, being accused of being a creep, allegedly, I'm not sure he walked around with no pants on at ABC News, but whatever he was doing that his employees accused him of being a creep, yeah, I think it would have helped if we had the injunction on the record. Absolutely. Look, I have many flaws. We all have many flaws, but I'm also I strive to be principled, ethical. I create problems for myself because I care about things. It's on me. I have to lower my expectations. I got a call from one of the co-founders of LionTree, because I sent them an email saying, why are you investing in an alleged sexual deviant, basically. He called me up. He's like, what the, what? He's like, why? And I said, and in the end, he was like, you, Ash, owe me an apology for this email. I'm like, I have no problem apologizing. But no, I go, I told you last year, you all put your head in the sand. I didn't want to bother you, but I told the crew. And he's like, I empathize with your position. He goes, I actually do empathize. I said, that's all I want. I'm not crazy, because last year you all kind of made it. But you do have to in life get to a point where you don't care. Remember that line, stuff that matters, stuff that doesn't? I'm getting to a point where a lot of stuff doesn't bother me. Like with the Madame movie producer, it's true. Right now, there's no Netflix production paying them $1 billion. So if I were to, even for discussion purposes only, file a lawsuit, forget prevailing, I'm right now just kind of claiming emotional harm. It's once the 3 years would start once I'm like, oh wait, Netflix is paying you $100 million per episode. That's the harm now. It's financial, it's measurable. But you also get to a point where you're like, you have a good life. You clearly are also combative, like you like this stuff, but to a certain point. But there's always something. And guess what? That's the hidden cost of success. I don't even share 90% of this stuff because I'm like, why would I bother my team with it? But there's always going to be stuff. When you are an entrepreneur and you have any degree of success, it's exponential. There's more stuff. Ben Sherwood, I'm alleging here, probably saw that his son was on Watch Mojo. People who used to say Mojo is chauvinist, now that we've had success, they're like, hey, that's a cool name. Hey, why don't we use Mojo? Well, they're kind of using it, but there's no trademark. Oh, you know what? It's some peasant from Montreal. It's a lack of respect. But so am I upset more? Is it pride or is it legitimate business? It's a bit of both, but it's a legitimate concern because, again, if I didn't mention it, Ben Sherwood was accused of being a creep. You understand? So it's like, do you let everything bother you or not? What I've always said is, depending on what is bothering you that day, that's a sign of your privilege, your great life. If you're not worried about paying rent, your illness or whatever, you're in the top 1% of lucky people. But there's always stuff you just don't see it. People don't want to admit it. Do you know what these stuff happen to a lot of people, but most people are embarrassed to admit it. You know, it's embarrassing. You meet a movie producer, you want to invest in their company and partner. Most people are going to be too ashamed to say, hey, I met her and she's now doing a project on a book that I always wanted to turn into a TV show. That's embarrassing to most people. But to me, I'm like, hey, it's an idea. I had many ideas. Would I do that to others? I'm a different person with many flaws. You know, so you also have to let not to get you, or just use them for a course at McGill. Anyway, so statute of limitations prescriptions, you got 3 years, don't sit on your rights. Be careful. For better or worse, during discovery, when you are deposed, depositions are like mini trials. You have to open up, you have to talk about everything, you have to give emails. It's like if somebody goes, do you have an email? I was always thinking, you know, I'm always envisioning this eventual scripted universe. I was like, the day when I emailed Madame Movie Producer, she's like, shit, I'm not saying this actually happened. She found my Alexander the Great book that she had read and, you know, made notes on, and she probably threw it in a chimney, set it on fire, and was like, I've never had this book. Because during a deposition discovery, if my lawyer goes, did you, Ben Sherwood, talk to your counsel at your company about the risk of Watch Mojo and Crazy Ash up in Montreal filing an injunction and accusing us of trademark infringement? He is on the record, on oath. It would be like lying perjury if he says no. If there's an email that says, yeah, we actually discussed this. That's why a lot of people don't want to have emails. With me, writing a lot of emails has helped me and hurt me. So it is what it is. Bill Gates, do you guys remember those emails in the late 90s when the Department of Justice was going after them for antitrust? There was a lot of emails that they dug up. Bill Gates thought he was untouchable, but those emails come back. So be careful what you put in writing, but at the same time, sometimes it could save you. I have a situation that eventually I might discuss a bit more, where things I wrote down created headaches, but things I wrote down also context into things where it's not just my word versus somebody else's. Definitions change. If you're interested, by the way, when I share this, you can link on all these and go read it. Damages means very different. Damages in copyright is actually very different than damages in an injunction. It's actually a clear paradox and inverse. In injunctions, damages have to be impossible to measure, meaning if I don't grant you an injunction, the damage to that business would be so hard to measure that there's no price to be put on it. So to avoid irreparable harm, immeasurable damages, we're going to err on the side of caution and give you this injunction. So it's actually, you can't quantify it. In copyright, it's the opposite. If Eminem comes and says, hey, Watch Mojo, they took 2 minutes out of my 2.5-minute song, put it on a top 10 list, but they took the heart of my song. Everybody listened to it for free in their top 10, but whereas historically I would sell 1 million iTunes, my song, and stream 10 million streams on Spotify, this time because of Watch Mojo's infringement, alleged infringement, I only downloaded 5 iTunes and only streamed 10,000. Clearly, I lost $3.7 million. I could measure it to the dollar precise. Watch Mojo, you owe me $3.7 million. Now that's his alleged, claim. We then go to court and the judge goes, okay, is it infringement, yay or nay? If it is, could you measure the damages, right? So damages doesn't always mean the same thing. Industry context. Again, if you go work in the tobacco, when I graduated from Concordia, a lot of my classmates went to Imperial Tobacco. It's a free world. We're not North Korea. Understand what you're getting yourself into. If you go work at Facebook, yeah, people are going to accuse you of working for a crazy company, right? I say, Watch Mojo, we work with fair use. I can't be a hypocrite. It's part of what we do. It's like running a club. Some guy's going to get drunk. Some other guy's going to vomit. The cops may show up every other night, but I want to be in a bar, loud music, booze, party, blah, blah. It comes with the territory. I decided to go work in media and entertainment where first of all, we draw all the crazies, creative crazies that have some insecurity or backwardsness that they can only feed through this kind of creative expression. Yay. But on top of that, unfortunately, it's an industry that enables real bad apples. Harvey Weinstein, Bill Cosby. Remember when I went through every Les Moonves at CBS, Ben Sherwood, if I didn't mention him already, at ABC, Matt Lauer at NBC. These were not obscure cases. Les Moonves ran CBS. Matt Lauer was the face and voice of NBC. Ben Sherwood decided what stories were told at ABC. Bill O'Reilly at Fox. Sarah Palin said, I will not be in an office alone with Roger Ailes, who ran Fox before he died. So these were not random bad apples in the back. These were the leaders of these organizations, right? So you have to kind of sometimes understand that not defending wrongdoers, but if you go work at certain companies and if you go work at certain industries, there's some baggage that comes with it. And so again, for me, I don't say I don't regret, but you know what? When I finished my Bachelor of Commerce from Concordia University, John Molson School of Business, school down the street, I was like, I want to teach, but I needed a master's. But because my teacher had asked me to be a TA, and I was TAing at McGill, which did not allow me, accept me in the management, I got in at the arts program. I was like, great, it's fun. You know, it's like kind of, I got to prove something. And at Concordia, I did that for a year and a half after I graduated, whereas I was like, oh, I should have done a master's. Because if I do a master's, then I could teach. But in a way, everything happened for a reason. By not teaching, I kind of said, okay, let me pursue an entrepreneurial path. And I love that journey that I went on. But so I don't really regret not doing a master's. It's really not like I don't lose any sleep on it. I'm glad I didn't end up teaching. I love doing this, as you could tell, but everything worked out for a reason. The final takeaway is the truth always comes out. What I learned with the News Corp lawsuit was, wait a minute, bizarre as it may seem, I just have to speak the truth. I didn't have to go fabricate, and lawyers want to oversimplify things, but I was like, you just have to speak the truth. If you speak the truth, everything else kind of falls into place. The main thing to understand is when you are raising money, you are going to pay for the investor's legal fees out of the money you raise, okay? If you are an entrepreneur, these are documents that the VCs are circulating. It's early stage. They're looking at like 100 things. 2021 and 22, there are so many precedents that you could review them and obviously share them with the lawyer. But if you go back and push on things that are industry standard, I don't necessarily think you're going to have the leverage that you do. If you are a 4-time entrepreneur with 3 exits and you've sold billions of dollars, you get to set the terms. So that's the missing context. And like, you know, if I was starting a new company tomorrow, yeah, I would probably say like, hey, these are the terms I'm looking for. Otherwise, it doesn't make sense. But I'm the same person, but 20 years ago, I would have agreed to practically everything, right? And the more you drag it out, the more your legal fees grow. So one thing. The other dynamic is in the last 10 years, there has been the rise of a SAFE. Simple agreement for future equity financing. So SAFEs basically really simplify that process and have taken a lot of the complexity out of it. So you could basically say, look, it's like a convertible round where you invest $500,000. You accrue 5% interest, which we don't pay out, but you accrue it. And then when later on we go out there and raise a real round where an investor comes and says, you guys are worth 10 million, you convert your 500,000 plus your interest into equity at that round. And we cap the valuation, meaning if you're coming in now, you not go above 10 million. So if we raise money at 20 million, you're basically getting almost 2 for 1 on your investment. And we'll even give you a 10% discount. So if we're raising at 10, you come in at 9. So there's not that much complexity, although it's a great question, and I will update it when I share the class notes. It's a great question, but it's pretty much standard now. It's like you're either raising a SAFE or you're doing around where the VC largely, and the key though is like, there's another point to make to that question, which is you really want to interview your lawyers well. You want to ask them like, how many of these deals have you done? You know, like in litigation, how many of these things have you debated, contested? You know, so if you go to any law firm that has done this, you know, and they practice in like startup financing, they will be able to flag any draconian red flags. But it's such a pro-entrepreneur environment. I don't think, unless you're raising money from like a loan shark, it's pretty standard. The employment share ownership program generally starts with equity for like founders, but then starts with options for early employees, and then they vest over a period of time, sometimes 3 years, 4 years, 2 years, it depends. And the idea is that, like, again, competitive, so you might have to sometimes give somebody a quarter of their options after 1 year, and then they vest every month, pro rata. But you want to protect yourself and give people options. And then options, generally, when people leave, they have like 60 days to exercise. You know, one good thing of setting up the ESOP finally was later on when I hired a lot of very expensive executives, it didn't work out with all of them, not because they're bad people, they're great, but there just wasn't a fit. When they left, there was no room for confusion. It was like, hey, this is our share ownership program, this is how it works. So it wasn't he said, she said. The thing is, when you're getting options, you do need to understand that, like, it's not the option prices that matter, it's the valuation of the company. Your options could be 10 cents or $5, but if you're getting options from like a company that's worth 10 billion on paper, it's probably not going to be in the money ever. There was a company here, Element AI. Element AI did the largest Series A investment, I think, in Canada, 104, 106 million Series A, which is crazy. So they got valued probably, let's say, at 200-300 million. So if you're an employee, you arrive there month one, there's zero value in the business really, but because of this transaction that an investor said, I'm going to give you 100, it's like, I'm going to give you my two $500,000 cats and you give me your $1 million dog. It's like a popular saying. So you get options in this company, and your options are, the company's value is 250 million. Your options are only worth something if the company grows in value. But if the company shuts down and sells for 50 million, you get zero.